Good morning. Occasionally, the police were compelled to register case not only uh, the required offences, but they are thrust to register a grave offences. Just if any building is collapsed, if somebody dies, the owner of the building is being charged for an offence under section 304 part 2. Electrocutions, manual, so many things are there. So the time to time the courts are also taking serious view of the matter, and when seeking for anticipatory bail they immediately called the accused to deposit certain amount in favor of victims. These all are things are happening. So many multiple cases have been discussed in the judgment which I am going to discuss with you. AR 2025. Supreme Court 1515 AR 2025. Supreme Court 1515 Yuvraj Lakshmilal Kanter and another versus State of Maharashtra. The owner of the company which deals with interior decoration, while working on signboard, some electrical wire seems to have been passed and two employees died. So these accused owner of the vehicle, owner of the company were charged for 304A and 304 Part 2. The discharge application the 227 was filed. So the Supreme Court has categorically held, stating that dealing with 227 discharge is totally different, because it is duty of the court to just consider the record and document submitted, and here the submission of the accused. They simply say the court is not required to undertake a threadbare analysis of the materials gathered by prosecution. So they say you have to apply your mind. Sometimes the court say file discharge application. We need not file discharge application. We can simply argue. But judges says we are forced to file application. Supreme Court has said, see, there is absolutely no evidence that accused failed to provide any safety equipment to the deceased, because deceased was climbing by ladder and the electricity passing through was an accident. That was Supreme Court said. So far 304A is concerned and sometimes 304 Part 2 is concerned, reason to believe good faith res ipsa liquidator should apply. Here, if the employer would have provided a improper ladder, and if they failed, if the employee fall and death, then that is the crime. Here they held that, and accused were also discharged by setting aside the dismissal order of the lower court as well as high court, when the appellant before the Supreme Court filed an application to discharge. Go through the judgment, multi-number of discussions were there. Very good judgment. Best wishes.